एक बार चुप कर गया।
So there are 83 participants already, 88 already.
Yes, you can see.
Good afternoon, ladies and gentlemen. I, Rajul Jain, on behalf of Indian Council of Arbitration, I welcome you to this webinar on the topic Third-Party Funding in Arbitration, Ease of Doing Business in India. As a part of the India ADRV, this webinar is hosted by Indian Council of Arbitration, which, as we all know, is an apex arbitral institution in India, which was founded way back in 1965 as the arbitral body of national importance through the joint efforts of Government of India and FICCI. IC has been steadfast in its mission to facilitate amicable, swift, and cost-effective resolution of commercial disputes through arbitration. In the current landscape, ICA not only stands as a prominent figure in the Indian arbitration arena, but has also garnered recognition as one of the most esteemed and trusted arbitration centers in the Asia-Pacific region. In a recent study conducted by the Federation of Council of India, it has been voted as the most preferred arbitral body in India. Today, we are honored to have with us Mr. N.G. Khaitan, President of ICA and Senior Partner, Khaitan and Company. With decades of experience behind him, Mr. Khaitan has provided invaluable advice and representation to clients across a wide spectrum of legal domains. Mr. Khaitan is a trusted advisor to prominent industrial houses and multinational corporations, offering strategic legal counsel on a multitude of matters. As the President of Indian Council of Arbitration and President of Bharat Chamber of Commerce, Mr. Khaitan is a distinguished figure in the legal and business community. He frequently lends his insights as a key speaker on various legal subjects, contributing to the discourse on different branches of law. Without further ado, I invite Mr. Khaitan to lend his views on the topic and the opening remarks for this webinar. Welcome, sir. Over to you.
Thank you very much. Since this is an India ADR week, I must compliment ICA for organizing this very important topic, third-party funding in arbitration and doorway to ease of doing business in India. This is a very debatable subject. In fact, this particular issue emanated from France long time back, and then from England, it was basically adopted by the USA. And USA, this issue is very prominent. I mean, we know that the large amount of compensation which people have got in USA. The issue is that even in USA, certain states don't allow, the third-party funding. That there are many states will allow third-party funding. There are certain states which allow third-party funding with restrictions. So, and apart from that, the point is there is a very lucrative business as far as third-party funding is concerned in USA. You see, last year, 4 years back, there was an election between Mr. Biden and Trump. And in that, the voting machines were supplied. And the Fox News said that the voting machines were rigged, and the elections were also rigged. And the Fox News was, and the company which filed, we had manufactured the voting machine, he sued the Fox News. And you will be surprised that there was a compensation awarded was $787 million. And there is a lawyer in America who specializes in this particular subject. His name is Mr. Sushman Godfrey. And his piece was 1/3 of this compensation. So you can understand then in another case, again, Mr. Sushman Godfrey in 2018, he filed another case where a compensation was to the extent of $106 million, and his fees was 1/3 of the compensation amount. And even in last year, one of the insurance companies in USA, there was a breach of contract, and the insurance company did not allow the claim to be passed on, and a suit was filed on a Champati agreement, and there was a compensation to the extent of $92.5 million, and also 1/3 of the amount went to the So therefore, it's a very, very lucrative business, but it has a lot of pitfall also. Now, the question here is whether, since I have only 5 minutes, the question here is whether we should allow this in the arbitration or not. You see, the Supreme Court in Balaji judgment has already said that there is no bar in allowing third-party funding, uh, third-party funding in arbitration proceedings and in litigation proceedings. But the question here is that this third-party funding, unfortunately, is not permitted by lawyers in India, because the Bar Council of India rules really prohibits the lawyers from doing this party business, because they say that if you have any pecuniary interest in any litigation, you cannot participate. The Bar Council of India rules provides that. So therefore, as far as the lawyers are concerned, they are not allowed to enter into an agreement. But we know that this is happening in India, even if it is not allowed by the Bar Council. Secretly, it happens in India, and particularly in the lower courts. What has happened today is that the Code of Civil Procedure has been amended, and number of states has amended Code of Civil Procedure where they allow the third party funding to be allowed. And what the rule says, like in Maharashtra and in other states, they have Madhya Pradesh, they have passed a rule that if you allow a third party funding, then those persons must be made a party to the proceedings. If they are not made party to the proceedings, and the defendant may ask, they know that they must provide an indemnity also. So therefore, this is what and if they do not provide, they do not get they are not allowed the interest. I mean, even if they view a litigation, they will not be allowed the success fee. So therefore, these amendments have been made by certain states in the Civil Procedure Code, where they now allow third-party funding. So therefore, but in arbitration law, there is no such mandate of allowing the parties to be added as third-party. So therefore, the point here is that what we should be doing. If you see the arbitration law of other countries, the China allows it, and they have to be added as a party. ICC rules allows that third party funding, and you have to be made as a party to the proceedings. So there are many arbitral jurisdictions which allows that. The question here is, should ICC also allows that? Now the question here is that whether we should, because if you don't make them as a party, what is the sanctity? Suppose they are not made a party to the proceedings, and a person concerned have a success fees, then what is the procedure that he is going to get that money unless he is not a party to the proceeding? Similarly, there is an award of cost. Now you go for a success fees. What about if they are, as a litigant, instead of getting a claim, you are awarded cost? Now, he is only funding for the success fees, but as far as the cost is concerned, who pays the cost? So therefore, I basically feel that this is one area which has to be considered. All over the world, the third party funding is allowed. I think there is no reason why it should not be promoted in India. And if it is promoted in India, there is a lot of pitfall. Everything has a pitfall. It has a good side of it, it is a bad side of it. Some people say that the litigation becomes a speculative litigation. No person is going to invest something and put money unless he's damn sure that this is not a speculative litigation. So he's going to put in his good money only when he sees that the person concerned to whom he is funding has a good chance to succeed. So otherwise, he is not going to, because he's going to look into all his cost papers. The question of confidentiality comes in. A lot of issues comes in. Confidentially comes in. Then he participates in the proceedings. There can be a conflict of interest. Whom the lawyer will listen, whether he will listen to the third party or whether he will listen to his client, what the lawyers will do. So these issues are there. But I personally feel all over the world this is happening, and I think if you want to, because now, you you want that India should be a hub of international arbitration, and I think we should follow what is happening internationally. So I think it's a good subject. I have only 5 minutes to speak. It's a very good subject. In my personal opinion, third-party funding should be allowed, and if required, we should have necessary changes in the rules and regulations, necessary changes in the law, whatever is required. And I'm sure that this is going to promote arbitration. This is going to promote arbitration in a big way. And this is also going to promote litigation in a big way, because ultimately there are many people who have a good chance to succeed, but they don't have money to fight. So I think it is basically a good cause from which you are funding. And there is no harm when you have a success fee dependent on it. With those words, I would also request now the speaker. We have Mr. Mr. Chawla speaking, then we have Mr. Vivek Sood, we have Pinky ji. So I leave the the matter in their court. I think they will elaborate it in much greater manner and with bigger manner. But my personal view is that the third-party funding should be allowed.
Thank you, Mr. Khaitan, for the opening remarks and setting the tone for the further discussion. I will now invite Mr. Arun Chawla, Director General of ICA and former Director General of FICCI. Mr. Chawla had a long stint in FICCI, during which he witnessed the unfolding of economic reforms in India and has steadfastly worked to deepen the reform process across sectors, states, and dispute resolution process. Currently, Mr. Chawla, as the head of ICA, has promoted a healthy picture of India's arbitration practice. This has been achieved by organizing international conferences, facilitating international arbitrations, executing reciprocal cooperation arrangements and MOUs with major arbitral institutions all across the world. Mr. Chawla is a member of several government-constituted committees at the central and the state level and has also been a member of many overseas ministerial delegations. Mr. Chawla has been a speaker at many international and national conferences representing ICA and FICCI. We are privileged to have him, and now I invite him to take the session on understanding third-party funding in India.
Thanks, Raju. First of all, ladies and gentlemen, let me thank Mr. Khaitan for his wonderful overarching vision on the third-party funding in arbitration, and which, as we all know, will be a doorway to ease of business in India. Ladies and gentlemen, let me try and throw some light on the concept of third-party funding, its historical background and global perspectives. I would also like to emphasize on why it is relevant for India. Let me begin by defining what third-party funding entails. Let me use TPF as an abbreviation for third-party funding for convenience of speaking and listening. So at its core, TPF is a financial arrangement where a party not directly involved in legal dispute provides financial support to one of the parties involved in exchange for a share of the potential proceeds if the case is successful. Now, this practice is instrumental in covering the cost of legal proceedings, such as attorney fee, expert witness fee, other expenses related to the dispute resolution process. So while this concept may seem novel to some, it has a rich historical background dating back to ancient Rome and Greece, where financial backers supported legal actions in exchange for a portion of the recovery. Now, in the contemporary legal landscape, third-party funding has gained significant prominence globally, particularly in common law jurisdictions like the United States and the United Kingdom. Various legal systems and jurisdictions have developed regulations and guidelines to address TPF, ensuring transparency, ethical standards, and fairness in its implementation. Now, initially, I would say in England and Wales, the widespread use of TPF was not acceptable. But now England and Wales recognize TPF, and indeed many of the largest funders are prominent in the UK and London litigation markets. But of course, does not subject it to formal regulatory framework. In 2017, Singapore liberalized its approach to TPF by abolishing the laws restricting funding of litigation and expressly legalizing TPF in relation to international arbitration proceedings, as well as for the connected court proceedings. According to the 2017 law and regulations, the principal businesses of the funder must be the funding of dispute resolution proceedings. For the same, few requirements are also imposed on counsel, which must disclose the existence of TPF as well as the identity and address of the funder to the tribunal and other parties to the proceedings at their inception. In Hong Kong, enacted the Arbitration and Mediation Ordinance 2017, which permits TPF of arbitration. Of note is the obligation to disclose the existence of a funding agreement within 15 days of the conclusion of the agreement. This is imposed directly on the funded party, not on its counsel. In Australia, TPF has been recognized at the federal level. Now, let's turn our attention to why third party is particularly relevant to arbitration in India. There are several compelling reasons. Foremost is access to justice. One of the fundamental principles of any legal system is to provide equal access to justice. TPF plays a pivotal role in achieving this by making arbitration more accessible to individuals and entities who might not have the financial resources to pursue costly disputes. So it levels up the playing field and promotes fairness in our legal proceedings. The second reason is that TPF induces efficiency and speed. Arbitration, while often considered a faster alternative to traditional litigation, can still be very time-consuming and resource-intensive process. TPF comes to the rescue by providing financial resources needed to expedite arbitration proceedings. This not only reduces the backlog of cases, but also enhances the overall efficiency of dispute resolution. Thirdly, ladies and gentlemen, in the world of arbitration, costs and uncertainties can be daunting. TPF serves as a valuable risk management tool, allowing parties to share the financial burden and reducing exposure to adverse costs. This is particularly crucial in complex, high-stakes disputes. The fourth important reason is that TPF promotes investment. India's ambition to attract foreign investment is well known, well documented. TPF can significantly contribute to this endeavor by assuring investors that they have access to adequate funding for dispute resolution within India. This assurance can boost investor confidence and foster an environment conducive to economic growth. The fifth part is the legal reform and regulation. While India is actively working on regulating TPF to ensure transparency, ethical standards, and accountability, but this regulation not only safeguards the interests of all parties involved, but also enhances the overall credibility of the arbitration process in the country. So this will actually circumvent any under-the-table contracts. Number 6, another compelling reason for India to have third-party funding is that a robust arbitration system complemented by TPF can be a catalyst for economic growth. It reduces the time and resources spent on lengthy legal battles, encourages foreign investment, and creates a favorable business environment in India. Ladies and gentlemen, lastly, TPF can help India establish itself as an attractive hub for international arbitration. By providing the necessary infrastructure and support for complex international disputes, India can position itself as a preferred destination for resolving cross-border conflicts. Now, I'd like to give a few examples. To become an international arbitration hub, India needs to offer world-class arbitration services, including access to experienced arbitrators, legal experts, and infrastructure for conducting arbitrations. TPF can help finance the development and maintenance of such infrastructure. In a sense, TPF can help India create a conducive environment for international arbitration by addressing the financial and logistical challenges which are typically associated with cross-border disputes. We must also take note of the recent developments in India's judiciary regarding third-party funding. The decisions in Tomorrow Sales Agency versus SBS Holdings by Honorable Delhi High Court of a single judge bench in 2019 and by Honorable Delhi High Court of the Division Bench 2023. Now, this serve as crucial benchmarks in how India approaches TPF. While the 2019 decision raised questions about liability of funders in arbitration, the 2023 decision clarified that a funder is only bound by an arbitration award if compelled to arbitrate and is a party to the arbitration proceedings. So this legal evolution reflects the dynamic nature of TPF and its impact on arbitration proceedings. So in conclusion, understanding TPF is paramount for comprehending its role in making arbitration more accessible, efficient, attractive in India. So embracing TPF can lead to a more equitable and thriving arbitration ecosystem, benefiting both domestic and international stakeholders alike. So, ladies and gentlemen, as we continue our exploration of this fascinating subject, I encourage each of the participants to actively engage with ICA Secretariat in case any queries on the webinar topic or in relation to arbitration. We will be happy to listen to your insights and respond to your questions. Thank you.
Thank you, Mr. Chawla, for so lucidly explaining the concept, genesis, and the global perspective, and extending the relevance for Indian context. I will now go over to the next session, for which we have with us Mr. Vivek Sood, Senior Advocate, Supreme Court of India. Mr. Sood is a leading arbitrator, and he is well known for his expertise in different branches of law, including constitutional, commercial, arbitration, and criminal laws. Interestingly, Mr. Sood has also authored various books on arbitration, cybercrime, electronic evidence, immunity to internet intermediaries, electronic contracts, insolvency law, and constitutional issues like right to privacy. I now request Mr. Vivek Sood to speak on the benefits and challenges of third-party litigation funding. Thank you. Please, over to you, sir.
First of all, I must thank the organizers, Mr. Chawla, ICA, for giving me this opportunity to come on this platform. Third-party funding is a very interesting subject, very debatable, and I will straight away go on to the challenges. You know, I would not call them negatives. I would call them challenges of third-party funding in arbitration and litigation. First of all, third-party funding can lead to proxy litigation. That is, proxy litigation by parties, for settling scores other than the dispute in hand. Now, I have read about instances, for example, in the Gawker Media case. In the Gawker Media case in 2016, Hulk Hogan, he won a 9-figure lawsuit that led to the bankruptcy of Gawker Media. And it is said that a billionaire, investor had a personal grudge against Gawker Media. And therefore, he funded and sponsored this litigation. So therefore, the first problem or the challenge is the proxy litigation that may arise through third-party funding. Another challenge that is spoken about, written about frequently is the breach of privacy. The third-party funder may have a lot of access to information, confidential information. Arbitration is a private dispute, and if the resolution is, it is not to be put in the public domain. So third-party funders may have unnecessary access to information which may result in breach of privacy. The third challenge which I see, the hidden motives. The hidden motives, where the real motive may be something else rather than funding an arbitration. For example, in Reid Hoffman, he funded, this lady, Jean Carroll, in a lawsuit against Donald Trump. So, it is said that perhaps the motive was not to genuinely fund this litigation and this matter, and the motive was something else. Then, there might be a compromise with the victim's interests by funders. After all, funders will work for a profit. And ultimately, I don't know how much a small-time guy, who wants to fight a cause against a large corporation, how much will he get ultimately in the process? So that's another issue that is a challenge. Now, funders may also collude with the respondents and ultimately settle the dispute. So these hidden motives, etc., and then you may have multiplicity of litigation, the dispute between the funder and the victim. So these are some of the challenges of third-party funding. Now I come to the positives. The first positive, as Mr. Chawla rightly highlighted, and Mr. Khaitan also mentioned, access to justice. Now, access to justice is a very significant cause that for which we need third-party funding. A small litigant does not have the wherewithal, he does not have the resources to fight a high-profile or a high-pitched dispute, an arbitration with a large corporation, where you have retired judges of the Supreme Court and other arbitrators who charge a mammoth fee. So he may not have the resources. So third-party funding provides access to justice, which is a very important cause. Secondly, ordinary litigants through third-party funding can match the legal eagles who are engaged by large corporations. So therefore, third-party funding brings in equality, a level playing field, in the battle between an ordinary litigant, an individual, or a small company or a firm, when pitted against a large corporation, which has a battery of lawyers behind them. Now, with these challenges and positives, I see more positives. So, third-party funding is here to stay. It is a phenomenon. It is picking up. And India, we must harmonize our laws, with the global scenario. We can't become an arbitration hub in isolation. So we must globalize our practices, our laws, our mechanisms. Now, having said this, I would say that there is a need for a regulatory mechanism to strictly regulate third-party funding. In my opinion, it should not be left to the ordinary principles of freedom of contract, that X has entered into a contract with Y, and that will prevail, that will hold the ground for third-party funding. We cannot have that. After all, a small-time litigant will not have that bargaining power with the third-party funder. So therefore, we need these contracts to be regulated. Now, there are instances in the legal system where this regulatory mechanism is there. For example, RERA. It has been said by the Supreme Court time and again that these contracts between builders and home buyers are unconscionable. They are one-sided. They are exploitative in nature. So therefore, RERA as a statute has stepped in. So we can have a regulatory framework, to make these contracts fair and equitable to all the parties. Now, I must say, third-party funding, in my view, should initially start on the principle of necessity. We should not, it should be governed by necessity. For example, a suit by an indigent person under the Code of Civil Procedure, he can fight a litigation in the court of law without paying the court fee. So we should initiate this new concept of third-party funding through the principle of necessity, rather than going whole hog. And then we can open up gradually as the system matures, with more and more arbitrations come in. Then, you must have the regulatory mechanism, must have principles to identify the funder realistically. Who is the funder? Where is the money coming from? What could be the objectives, etc. Now, see, the identity of these individuals, this has been a subject matter of the Insolvency and Bankruptcy Code. For example, of 2016, an interested party. So to ensure that no backdoor entries are there in this third-party funding process. Now, I'll just summarize. While there are challenges, there are positives. In my view, the positives far outweigh the challenges and the negatives. We must embrace third-party funding in India. Of course, I must flag it by saying that there is a need for a regulatory mechanism to have that framework within which the third-party funding will operate. Thank you. These are my views on the subject. Thank you.
Thank you, Mr. Sood, for a wonderful session and the clarity with which you have touched upon the various aspects which are relevant to third-party funding, and actually setting the tone for the next topic of discussion by Ms. Pinky Anand. Before I hand it over to Ms. Pinky Anand, I would like to introduce her. Ms. Pinky Anand is a senior advocate. She is a former Additional Solicitor General of India, who is also an arbitrator with Singapore International Arbitration Center and Dubai International Arbitration Center. Ms. Anand has represented our country in various national and international forums, including BRICS and SCO. Also, Ms. Pinky Anand is the chair of the ADR Committee, Business Law Section of Law Asia. A governing body member of ICA, Ms. Anand has been awarded the French National Order of Merit by President of French Republic and several awards acknowledging her contribution to the legal world and society. I now invite Ms. Anand to take over the session and enlighten us on the issues of regulation, existing gaps in regulations, what are the international best practices, what are the notable cases, and what are the interpretations that we see the courts passing on TPF-related issues. Over to you, ma'am.
Thank you so much. Indeed, coming on the footsteps of such eminent speakers, starting with Mr. Khaitan, the president of ICA, with Mr. Chawla, and then Vivek, my dear colleague and friend, also a very good golfer. I must say that the conversation today has already gone through the various channels. But what is interesting for me today is this. I think we are at the threshold and maybe a little couple of steps more in this entire world of arbitration and of how to promote efficiency, stability, investments, drawing in arbitration into India. And in that context, one thing is very clear. Third-party funding is here. It's not that it is not here. What is not illegal is legal. That is a broad interpretation. And by now, the various judgments across, right from, in fact, Privy Council onwards, have held that third-party funding is permissible. Of course, as Mr. Chawla said, it is also permissible under the Civil Procedure Code. We already have under Order 25 a provision for, Mr. Khaitan, in fact, had pointed that out, that you already have such a provision. And today you are having a position where the Bar Council notification has come in, which is now inviting foreign lawyers to come into India, which has opened up the field for foreign arbitrators, for foreign lawyers in arbitrations. The Arbitration Act itself has opened up the doors for an arbitrator to be appointed a foreign arbitrator under Section 11 by virtue of an amendment. So you have third-party funding come in here to stay. And incidentally, while we are at it, about 2 years back, I actually wrote a paper to the government asking for third-party funding to be considered. I can't say that I asked and demanded for it to be taken up, but it is because the whole idea of third-party funding is to promote a system which lends itself to investments, to claims, to adjudication and, as the earlier speaker says, access to justice. Because everybody must have an access to justice. And in particular, arbitration is different from litigation. Litigation has other factors into it, but arbitration is party autonomy. Ultimately, it is resting itself on the parties being able to select. So if parties want to undertake their cases, do we want to go into the old chapters of champerty and maintenance, or have we come into a day and age where you can have funding for the purpose of getting your rightful, just claims and access to justice? So if you go back just to that, you actually had Justice Denning, Lord Denning, say at that time, is the wisdom behind champerty and maintenance, the noble profession of law and justice, be tempted for his own personal gain to inflame the damages, to suppress evidence, or even to suborn witnesses? That is Lord Denning's statement on champerty and maintenance. Incidentally, in some judgment in India, it was held that it doesn't apply to India. And on the other hand, you have Sai Ramani Garimella, and another noted academician, who said it is no longer appropriate to use the doctrines of champerty and maintenance as blunt instruments with which to strike down third-party funding arrangements. A more qualitative and purpose-oriented analysis of the nature of arrangement concerned needs to be undertaken in order to assess the risk that such arrangement would hold for the integrity of the arbitration in a given claim. Another viewpoint that I think is rather important at this stage, if we are already having third-party funding, of course, without the lawyers being able to undertake that, Balaji and the entire law downwards has held that lawyers cannot undertake such third-party funding arrangements because it would strike against champerty and maintenance, which is prohibited under the Bar Council regulations, not under only regular laws, but our own professional laws. So do you need to have a system? And if you have a system, should you have regulation for the system? So my inherent belief is, if you have a system which you're operating, then ensure that the regulations fall into place so that everybody can then, in fact, manage either the benefits of the system or the vagaries. And unless and until you have regulations, you can't do that. In fact, as I speak, as we all know, the high-level committee, which is under the chairmanship of Justice Shri Krishna, has already recommended third-party funding. The matter is under consideration, and in fact, possibly some part of the process of putting together the regulations such a system is in place. The Mediation Act, incidentally, was notified as we speak, something again which has been in the offing. On a different note, similarly, third-party funding is also something which we have accepted in all principles, and as I said recently in Balaji's judgment, for this effect. Now to come to what might be the international best practices, because that is always a goal that we look towards. Mr. Chawla mentioned rightly the various jurisdictions that have already undertaken third-party funding and have systems in place. So we have Singapore, we have Hong Kong, we have Australia, and we have UK. In various ways, these, and USA, of course, as Mr. Khaitan said, which have put it into place. I just want to outline some of the features which Vivek also pointed out recently that would be advisable to look into. It is important to know the nature of funding. Now, for that nature of funding, I am not for knowing what the funder does behind the situation, because that would not really be a part and parcel of the entire exercise. But to know the credibility of the funder is something which is important, and financial credibility, because ultimately he is undertaking a business of funding. So to that extent, if you see Singapore, for example, just a few of the very the legitimate concerns that they have voiced within the legislation is they've abolished the tort of maintenance champerty. They have decided that legislation on validity of certain contracts only can be funded by qualifying third-party funders, which includes, incidentally, arbitration, court proceedings, mediation, stay proceedings for enforcement, mediation proceedings, and then proceedings commence in SICC, which is there. And one of the conditions is the classes of proceedings which can be funded, and rules to qualify as a third-party funder as parties with a paid-up share capital of Singapore $5 million, and the applicant shall be a company that carries on, as Mr. Chawla said, the principal business. The principal business will be that of funding. Now, the Ministry of Law of Singapore described the benefit for businesses as it could offer an alternative avenue to fund meritorious claims and further strengthen Singapore's position. Hong Kong, let's see the practice of Hong Kong, has introduced the arbitration and mediation legislation of 2017, applying both to international and to domestic arbitration. And there are 3 exceptions to champerty for third-party funding: when the third party establishes legitimate concern in the outcome of legislation. This is what Vivek was just outlining. So there must be a legitimate concern. The concern, money is not the issue. If you expect to make money in a proposition, that itself is not wrong, but there should not be a vested interest in having some malicious prosecution or otherwise, or vested interests. The second that Hong Kong establishes is the party should persuade the court that it should be permitted to obtain third-party funding on the basis of accessibility of justice. So the means, that somebody should need the means to some extent, what against Vivek was voicing as maybe in forma pauperis kind of proceedings where people need the money, otherwise they are unable to pursue it, but not to this extent. The third is lawyers are permitted to fund arbitrations as long as they do not have an interest recognized by law in the arbitration other than the funding arrangement. So therefore, if it's a financial interest by itself, that can be permissible even for lawyers in Hong Kong, which is one of the practices that are adopted there. But of course, we would need to look at it in a different perspective in the Indian context. The UK itself follows a code of conduct for litigation funders, which is a voluntary self-regulation mechanism, which includes a mandate of minimum of £2 million as capital. Incidentally, I would not suggest the same for India. While we're looking at the international best practices, I do feel that we need to have a regulatory mechanism which would set out the required paid up share capital rather than to leave it to a voluntary mechanism. And this, for example, in UK, the £2 million capital is required to be audited by a recognized law firm and a detailed complaints procedure. I think this would kind of put together a perspective of permitting the authenticity and credibility of the funder. Now, just to flag off while we are talking, a number of concerns that arise in third-party funding and which will continue possibly to arise even as we speak. A number of them are out in the market, as we say, and it is being experimented across in various jurisdictions. For example, disclosure. To what extent does the arbitral tribunal, have control over the funder to find out about either the arrangement of the agreement or about the legitimate concerns? So to that extent, broadly, the consensus has been that the agreement can be asked to be disclosed in some cases. Of course, some have been rejected, but only to the extent of the funding. It doesn't go beyond that, and to the extent of the financial capacity and credibility of the funder, which is a material consideration and cannot go beyond that. The second concern that comes up in third-party funding is confidentiality, because as we rightly know, the investor-state arbitrations, commercial arbitrations, international commercial arbitrations, there are large infrastructure disputes. As you know, the kind of funding that has come in, for example, in India, in investment-related arbitration disputes is to the tune of USD 9.2 billion. And that also figure needs to be updated. And the cost of arbitration is about USD 5.3 billion. So in considering the stakes involved, the confidentiality and the complexity of the nature, and sometimes, of course, in investor-state arbitrations, you even have state secrets and other issues which have to be disclosed to some extent when a funder comes into the story. Why does a funder fund? A funder funds a fundee because he has an interest in the outcome to the extent of a monetary gain and a stake in the investment. So he has a right to know, but to what extent does that invade confidentiality is a major concern, and of concern for all of us. Third-party funding, thirdly, may manipulate parties. And that is, again, an issue, for example, in social kind of context, even more than commercial. Because you may, for example, promote, let us say, public interest litigations or environment, let's say. So there's a stake of a party against several parties, or there may not be a stake of several parties, but you ultimately have a third-party funder who wants to instigate some kind of issue against the respondent, so to say. So you ultimately invite litigations and promote them so that you can have some kind of action against a body against whom you have an interest. Or take the vice versa case. You want the respondent to lose. You want the petitioner to succeed. You want the claimant to succeed. In that case, you promote the litigation in such a way that you actually have that outcome. So we have to ensure that a funder will not control. Fifth, to what extent should the funder have a control over the arbitration? And this, incidentally, I'll just voice it because of the time issue, that there are two kind of issues that are there at play. There's a question of access to justice. So can a claimant forsake? One is to get access to justice through a funder. The second is, can a claimant forsake his or her right to access to justice by giving over or selling over his rights to the funder? So in this case, A is a funder B is the fundee, and B has a claim of 100 crores, sells it over to A for 80 crores and walks out of the litigation or the arbitration, and lets A undertake the entire process. So some degree of control of the fundee is essential, if not all of it. All control cannot be vested and divested by the fundee in the hands of the funder, because that would lead to adverse consequences, which possibly there would be no control of. The last possible concern, and there are several possible others, but the concern would be the payment of security and payment of costs. What if the award is against the claimant? And what if that is a fundee and the funder is funding? So how do you ensure that? In civil litigation, as we were mentioning, Order 25 CPC, for example, allows the court to implead the funder. Should you be allowed to implead the funder? Can a funder be a party to the arbitration? When it is a question of party autonomy, there are two parties to the arbitration, or three parties, whatever it might be, as the case may be. You cannot import another, but we must, and I park it there for all of us to consider, whether we should not have funder as a proper party to ensure compliance, of payment of costs, to ensure compliance of payment of security, and to ensure any other ethical questions that may come during the course of litigation. So with this, these are the various areas of concern. Litigations, arbitrations have considered these aspects, and while we speak, we are all grappling with it. So at the same time, we don't have time to wait. We do need to come on to the board. We have come on board as an international hub. We need to develop it even fast. The ICA, to which I belong very strongly, and other institutions, I do believe that India has everything to offer for a great international commercial arbitration, and of course also for domestic arbitration. So whatever it needs, people must have access to justice. And if that means funding, whether by way of hedge funds, by investment funds, by insurances or other means, as long as a credibility system can be put into place by a regulatory mechanism which withstands the scrutiny of any international best practice as well as our own domestic requirement, I think it is time that international arbitration faces and deals with third-party fund in India as speedily as possible.
Thank you, Ms. Pinky Anand, for the thought-provoking and expanding the scope of the discussion here. I'm sure all the participants have benefited a great deal, especially because third-party funding in arbitration, in litigation is such an upcoming topic, and it is of so much relevance. Now, I would like to invite Mr. Arun Chawla, DG ICA, to deliver a vote of thanks.
Rajul, I must say it's not only the participants, but I personally feel very enlightened by listening to the eminent speakers in the session. So, ladies and gentlemen, as we draw to a close, let me extend my earnest appreciation on behalf of ICA to each and every one of you who joined us today for this insightful virtual session on third-party funding and arbitration. Our sincere thanks go to Mr. N.G. Khaitan, President of the ICA, for his presence and support. Mr. Khaitan's leadership and dedication to advancing arbitration at ICA and India are truly commendable. His expertise and legal acumen have greatly enriched ICA's mission to promote India as the favorable destination for arbitration. I also extend my heartfelt thanks to Mr. Vivek Sood, Senior Advocate of the Supreme Court of India, for sharing his valuable perspective on the topic. Mr. Sood, your perspectives, your insights have added depth and content to our discussions. Ladies and gentlemen, last but certainly not the least, I express my deepest appreciation to Ms. Pinky Anand, Senior Advocate, Supreme Court of India, and former Additional Solicitor General of India, for her enlightening contributions to the webinar. Ms. Anand's comprehensive presentation has illuminated the path towards a better understanding of third-party funding and arbitration and the need for regulation. I would be remiss not to acknowledge the efforts of the Secretariat of MCIA and Ms. Neeti Sachdev, Secretary General of MCIA, who worked diligently behind the scenes to ensure the seamless execution of this virtual gathering and for their unwavering commitment wonderful planning, tireless coordination to make this webinar possible. So, ladies and gentlemen, in conclusion, today's webinar has been a journey of enlightenment and discourse, and I believe that the knowledge shared here will have a lasting impact. So, as we conclude this event, let's carry forward our insights and ideas generated here to continue our collective efforts towards making arbitration more efficient, accessible, and conducive to business growth in India. We do look forward to future collaborations and discussions on topics of significance. Finally, have a wonderful evening. Thank you.
Thank you.
Any queries or comments can be directed to the ICA Secretariat through email. Thank you. Thank you, everyone.